Hey everyone, it's KS here. On the 8th of May 2022, the government announced a new additional buyer stamp duty of 35% on any apply of transfer of residential property into a living trust. So in this video that we'll be sharing with you, we will have an update on how is this new law different from the past, all right? And if you have already watched a previous video that we have set up previously, you definitely do not want to miss out on this one because this gives you the added information that you need to know on how these so-called new trusts could still be mitigated by a certain sets of rules that we need to abide to. So again, we look forward to see you on this video that you can click on the top right to actually access it. And of course, if you have not catch up on the previous video as well, we hope you take some notes on it while you're on it. All right. So enjoy the video and see you soon.
The second question, which also arose very frequently, when can we start processing the refund? And obviously, the third question that always arises, okay, is can I really get back my money because it's 35% upfront?
Welcome to today's so-called debunking the new ABSD in terms of trust purchase. So I believe everybody is very confused and overwhelmed since the 9th of May when this was introduced. So instead of just leaving everyone in the lurch and not knowing what's going on, I've decided to re-invite Mr. Cannis Seng from BR Law that last spoke about decoupling and buying in way of trust, right? So before I bring him on, I just want to share a bit of a backstory for people who have missed out probably our last session, all right? So this is a bit about Cannis. Basically, he's an expert in purchase by way of trust. He has more than 10 years in the conveyancing line. And of course, he's a conveyancing specialist dealing with property conveyancing and also expert in decoupling as well, all right? So without further ado, let's welcome Mr. Cannis Seng that will be sharing his thoughts, and of course we are very happy to have him here with us today.
Yes.
Hey, hi Cannis, happy to have you here again with us. Okay, so yeah, we spoke about a lot about this 9th of May introduction. So how have you been?
Okay, it has been very busy because I was really a little afraid that my phone would melt. So I think this is very interesting. Okay, some of these amendments to the law proposed by the Ministry of Finance. Okay, and I look forward to clarifying a little on this from a legal perspective on all of these new rules. Okay. Amazing. And to answering your questions.
Yes, amazing. Thanks for being here today. So again, I guess one of the first things they said is a living trust in definition. So what is a living trust in definition?
Okay, a living trust by definition is a legal document or a trust created during an individual's lifetime. Okay, whereby a designated person, usually the trustee, okay, is given the responsibility for managing, okay, the assets for the benefit of the eventual beneficiary. Okay, I think as the name suggests, a living trust, okay, in very layman terms, means that it's done up while the trustee, okay, is still alive. Okay, yeah, right. That's the simple explanation.
Yeah, right. So there are instances where people do it when the trustee is not born yet. Is that what you're trying to say?
It's more targeted towards those type of situations whereby the current rules okay, whereby the beneficiary is not identifiable. Okay, there will always be a clear trustee, but sometimes previously some of the living trusts that were done are okay. From what we understand from IRA's position, some of them don't state clearly who is the beneficiary. So that is part of the loop that is closed by IRAS.
Right, I see. So given the new so-called introduction of this ruling, what are most of the so-called questions that you have on hand that you felt will be very, very important for the viewers out there to probably debunk today? Okay,
some of it, how should I put this? Some of it has actually been clarified by IRAS, okay, across the space of the past week, okay, they have also amended their own FAQ, okay, and added to it, okay, through some of our conversations with IRAS officials. We have also clarified some of what they mean, okay, by some of the language that was used, okay, because there is, and I'm certain you all can appreciate, there's always some ambiguity in law, okay, and we've managed to clarify most, if not all, of it after some of our conversations with IRAS. Okay, so I think one of the first questions which arose is that, is inheritance affected by this new law? So where we've clarified clearly that, and similarly, so has the IRAS website. Okay, if you will your property, okay, your inheritance is basically not affected by this new law. Okay, the second question, which also arose very frequently, which has also been clarified by IRAS, is when can we start processing the refund? So the timeline given on the IRAS website is generally around 2 to 3 months, okay, for the full processing of this refund, okay. And obviously the third question that always arises, okay, is can I really get back my money, because it's 35% upfront, and that I think is going to be literally the law of the land moving forward, okay, that you have to pay 35% ABSD first, okay. Only after this 35% has been paid, then you can ask for remission based on the profile of your beneficiary, okay. So to a large extent, it is pretty much like the good old days lah, okay. Nothing really changes in relation to trust purchases, except with the exception of clearly your trust deed must be very clear, okay, with no conditions, okay, on the beneficiary, okay. And secondly, and more importantly, you have to come up with 35% cash first, okay. So all cash purchases, all trust purchases have to be by cash, okay. So this 35%, I think, is just a matter of juggling your finances around. Yeah.
Right. So you mentioned the first two clauses. There's one more clause that you need to abide with to make sure that it is a successful refund or remission. What is the third clause that they need to probably to abide to in order for that full remission?
Okay. What the website and to summarize, okay, will be the fact that you must have a clear beneficiary, okay. So you cannot obviously give this to your unborn child, okay, that will not work, okay. Must have the name, the NRIC and/or passport number, okay, of who is going to be the beneficiary, okay. Previously, I think when we did all of this, okay, all of this talk, that was always very clear. So that hasn't changed by much. Secondly, in terms of no conditions being set on the trust, okay, so that one, okay, to a large extent, we have clarified with IRAS, okay. So basically, IRAS intent is to make sure that this property immediately vests beneficially, okay, in favor of the child or the minor, okay. And the third thing, okay, that we have flagged out, okay, from all of this circular.
I believe there's a deadline for the application of the.
Okay. Right? Yes, is that within 6 months, okay, you have to submit your application, and needless to say that this trust should be an irrevocable trust. Okay, that means that you cannot, after you have done up the trust, thereafter go back and say that I've changed my mind. I don't want to give this to the child anymore, or I leave some ambit for me to, okay, cancel off this trust. Okay, so all of those clarifications, I think, have been very helpful.
Sure. So I have this question that I felt that probably the viewers out there that are looking at this recording would like to know. How is this different from the previous way of trust purchase before the 9th of May, where in the event if they were to buy someone that's identifiable below the age of 21 with 3 conditions being met, and again, since it's irrevocable, the child turns 21 and the child somehow decided to sell their property and then share the profits, would that also means that it is a condition, or it would mean that it's actually based on the beneficiary own free will? So that is actually the question I would like to ask.
Okay. So how it works right now is that it's actually it was previously already quite clear, I felt, okay, but as with the law, after a while we take clients' instructions and we try and muddy the waters a little. So now what IRAS is saying, don't even try to muddy the waters. This property, after you purchase by way of trust, will belong to your child. Full stop. Okay. Any subterfuge to say that you must get married, okay, you must graduate first, you must be old enough first to own this property, all of this subterfuge, or will be viewed as conditions, okay, and have to be removed from the trustee. Okay, so I think it's just now very clear, okay, and I cannot think of no simpler way than to put this. If you buy this by way of trust, okay, this property belongs to your child, belongs to the minor beneficiary. Full stop. I can't think of any clearer or simpler way to put it, to encapsulate all of these conditions.
Sure. I guess people who are out there listening to this would know what Kenny is trying to say and what am I trying to imply as well. And we are basically trying to be, one's trying to be a salesperson, the other one is definitely trying to be, acting by way of the conveyancing lawyer's job. So I leave you guys to read between the lines for these particular so-called correspondence that you're hearing right now. And of course, at the end of the day, what we really want to share with you here is that as long as you abide with the 3 so-called conditions, and of course, like what Candice mentioned just now, that this property is ready for your child. Okay, so anything that happens beyond that trust deed that is being done, I think that is really based on own free will, and we wouldn't want to be managing anything beyond that. Am I correct?
That's right.
Okay, fantastic.
Hey everyone, I hope the video has been helpful to untangle some of the so-called hearsay that you have basically here on the ground and whatnot. So again, if you enjoyed the video, do click on the top right to access to some of the other videos on trust as well. So do subscribe to my YouTube channel if you have not done so. And if you've done so, I hope to continuously to give you more added information and insight so you can mitigate through this very dynamic real estate marketplace. All right, we'll see you again soon. Take care.